If you're ready to begin, please begin.
Mr. Chief Justice, and may it please the court. My name is Brian Pounds, and along with my co-counsel Cody Miller, we proudly represent the petitioners, City of Balboa Bay, in today's proceedings. Petitioner respectfully requests 2 minutes for rebuttal. Your Honors, while there are 4 distinct issues before the court today, each and every one of those issues gives this court the opportunity to affirm the principle that the parties cannot simply pick and choose how and when the law should apply to them. In my time before the court, I'll be addressing the first 2 jurisdictional issues, demonstrating first why respondents' en banc motion was rendered untimely by Rule 49.5, and second, why a substantive ruling by the trial court is not jurisdictional prerequisite to interlocutory permissive appeal. My co-counsel will be addressing the final 2 issues related to the Balboa Bay bag ban, and fourth, the incident between Officer Taylor and Lucille Bluth. Turning now to the first issue, the en banc reconsideration issue. Respondents' use of the en banc reconsideration motion created a prejudicial procedural hurdle to the fair and efficient resolution of the issues. Respondents effectively weaponized en banc reconsideration to unnecessarily extend the time and cost of trial. Accordingly, this court should overturn the 15th en banc court for 2 reasons. First, respondents' motion for en banc reconsideration was rendered untimely by Rule 49.5. And second, respondents' pick and choose interpretation of Rule 49 is ripe for potential abuse. Turning now to my first point, that Rule 49.5 rendered respondents' motion for en banc reconsideration untimely. Your Honors, while the procedural history of this case is quite complex, the issue before the court is relatively narrow. And that question is, does when permitted in Rule 49.7 point to Rule 49.5? And this court's precedent and subsequent amendments to Rule 49 establish that it does. The full statutory text of Rule 49.7 states that when permitted, a party may seek a motion for en banc reconsideration within 15 days of the panel's denial of that party's last timely filed motion for panel rehearing or en banc reconsideration. And as Justice Stiles in dissent points out on the record at page 13, the when permitted language of Rule 49.7 is a clear reference to Rule 49.5 of the Texas Rules of Appellate Procedure, which require a rehearing panel to first modify its original decision before a party may seek subsequent en banc reconsideration. And that conclusion is supported by this court's precedent and subsequent amendments. First, in City of San Antonio versus Hartman in 2000.
Counsel, am I correct in saying that in Cruz versus Ghani, the Dallas Court of Appeals held opposite of what you're arguing today?
That is correct, Your Honor. But as the dissent points out in Cruz versus Ghani, the majority misapplied the 2008 amendments to the current rule and did not recognize that this court has departed from its pre-2008 amendment understanding in Hartman, which brings me back to the Hartman case. In Hartman, this court laid out 2 important conclusions regarding en banc reconsideration. First, under a prior version of Rule 49, the court stated that en banc reconsideration is a subset of panel rehearing, and that conclusion is carried through to the 2008 amendments, specifically the comment to those amendments where it states that en banc reconsideration is to be treated as a motion for panel rehearing under Rule 49. The second conclusion the court reached in Hartman is that while the motions are similar, they are procedurally distinct. And therefore, in that case, an en banc reconsideration motion filed after the 15-day panel rehearing deadline was timely. But that conclusion was overruled by this court's 2008 amendments to Rule 49. The rationale in the Hartman court was that it made no sense to impose arbitrary deadlines on the en banc court when they could simply grant the motion anytime the en banc court retained plenary power. But 2 years later, that's exactly what the court did. they imposed a 15-day deadline on motions for en banc reconsideration, demonstrating that the conclusion in the Hartman Court that the motions are procedurally distinct has now been overruled, and accordingly, every single provision of Rule 49 applies to en banc reconsideration, not just the ones that support petitioner's position. And as the record—
So, counsel, are you saying that motions for rehearing and motions for en banc reconsideration are identical?
No, Your Honor. Of course, they're not identical because the purposes of them are different, and there is an established order of operations of how to do things. However, they are procedurally identical in that every single provision of Rule 49 applies to those motions. Specifically, in this case, Rule 49.5 requiring the rehearing panel to modify its decision. And as the record at 14 points out, the rehearing panel did not modify its decision, and therefore respondents' en banc reconsideration motion was rendered untimely by the plain language of Rule 49.7 and .5. And that
under this application, then, does it require that every party who may consider an en banc review has to file that before they can? Do they have to file the reconsideration and the en banc at the same time? Procedurally, how does this application work?
No, Your Honor, they don't have to file it at the same time. They simply have to file it when permitted. So as the record points out, Justice Stiles in dissent on 14, there were two different times that the parties could have filed their en banc reconsideration motion. They could have sought review 15 days after the original panel decision, or they could have sought an extension after they filed their panel rehearing motion. And that brings me to my second point, that respondents' pick and choose interpretation of Rule 49 is ripe for potential abuse. As the record at 13 shows, Justice Stiles in dissent stated that this court in Verbeek v. Donner established that the reason we have these deadlines is to prevent the endless relitigation of the issues. But that's exactly what occurred here. As the record from 4 to 6 points out, this is the 5th time that a court will consider the final two issues before it today. And that is exactly the type of situation that Rule 49.5 is supposed to prevent. And going back to Chief Judge—
Counsel, isn't the when permitted, isn't that the point, that the Court of Appeals can allow that to happen? And in this case, they did. So the rules allow for what you may call an abuse of these motions, but it's permitted by these rules.
Your Honor, I would respectfully disagree with that because it did not comply with the plain language of Rule 49.5. And there's, when permitted, as Justice Stiles states, when permitted is a clear reference to Rule 49.5. And because it didn't comply with that plain language, it was rendered untimely. And there's nothing to support in the text of the rule that Rule 49.5 is simply written out of the rule whenever en banc reconsideration motions are the issue. And further, as 41.2c states of the Texas Rules of Appellate Procedure, the purposes of en banc reconsideration are to maintain uniformity of the court's decisions or in extraordinary circumstances. And neither of those was at issue here. Instead, after the rehearing panel denied the respondent's motion, for the first time, respondents raised their subject matter jurisdiction challenge as sort of a Hail Mary at the last minute to unnecessarily extend the time and cost of trial.
But counsel, subject matter jurisdiction can be raised at any time by any party or by the court sua sponte. So if a party discovers at a late date that there was no subject matter jurisdiction, isn't it permissible for them to raise that issue?
In this particular instance, yes, Your Honor, it may have been convenient to raise that issue after the rehearing panel had decided its case, but it's not the proper function going forward for en banc reconsideration because this court laid out a clear deadline of 15 days and when permitted in the provisions of Rule 49. And as the court stated in Verbeek v. Donner, we need to adhere to those rules to prevent the endless relitigation of the issues. And further, the respondents could have raised their subject matter jurisdiction challenge at any time. It wasn't here to maintain uniformity of the court's decision. It was to further extend the appellate process and extend the time and cost of trial to essentially force settlement here. And this is all before a jury has made any factual determinations concerning the case. And it's for these reasons that this court should overturn the 15th en banc court and find that respondent's motion was rendered untimely by the plain language of Rule 49.5. And now, turning to the interlocutor.
Counsel, if their motion was untimely, is your petition for review also untimely? How does that affect it?
Yes, Your Honor. Under Rule 53.7 of the Texas Rules of Appellate Procedure, this court would have jurisdiction to state that the en banc court did not have jurisdiction, and that's the issue before the court today. This court does have jurisdiction to make that determination, and that's the issue before the court today on the en banc point. Turning now to the interlocutory permissive appeal issue. The purpose of interlocutory appeal is to prevent a trial court from holding a second trial where an issue of law decided mid-trial is likely to be overturned by an appellate court. Respondents' imposition of a substantive ruling requirement creates an unnecessary procedural hurdle to the fair and efficient resolution of the issues. And accordingly, this court should overturn the 15th en banc court for two reasons. First, the statutory text of 51.014D does not require a substantive ruling by the trial court. And second, the imposition of a substantive ruling by the trial court requirement would create an unnecessary hurdle to the fair and efficient resolution of the issues. And turning now to my first point, that the statutory text of 51.014D does not require a substantive ruling by the trial court. Instead, 51.014D has two requirements. First, the order to be appealed must involve a controlling legal question. And second, the resolution of that question must materially advance the ultimate termination of the litigation. And as Michael J. Ritter pointed out in the Law Review article, Beware the Substantive Ruling Requirement, nowhere in the statutory text does it require that the trial court first make a substantive ruling. Instead, as this court pointed out in Sabre International Travel versus Deutsche Lufthansa, the jurisdictional prerequisites are that the trial court is satisfied that 51.014D's requirements are met and that the trial court grant jurisdiction. And as the record from 5 to 6 points out, the trial court's order in this case satisfied those two jurisdictional prerequisites. It involved a controlling question of law, and the resolution of that question, because it was a summary judgment motion, would materially advance the termination of this litigation.
But counsel, in this case, the trial court didn't identify those controlling questions of law. So is that a prerequisite to allowing this appeal?
No, Your Honor. As the statutory text states, it simply needs to involve a controlling question of law. And in this particular instance, as I'll go into more detail later, the trial court's rationale is almost irrelevant because summary judgment motions are reviewed de novo. The 15th original appellate court looked to the trial record, reviewed those judgments of law as the trial court made, and made their ruling based upon their de novo review. And turning back to the substantive ruling requirement, that requirement first appeared in the Fourth Court of Appeals in Gully v. State Farm, and that's important for two reasons. First, in that case, the Fourth Court of Appeals determined that it was not jurisdictional prerequisite, as the respondent contends here, for the trial court to make a failure to make a substantive ruling, but rather it was reversible error if the appellate court so found. And here, as the record from 5 to 6 shows, the appellate court did not find that reversible error. And the second reason that it's important is that the Fourth Court of Appeals has since reversed its position on the substantive ruling requirement. Instead, in Kenyon versus Elephant Insurance, a decision this year, the Fourth Court of Appeals determined that this court has already implicitly overruled the substantive ruling requirement in its decision in Sabre International Travel. And that is important because the Fourth Court of Appeals, the originating court of the substantive ruling requirement, has now reversed its position and determined that there is no substantive ruling requirement. And as the record at 5 to 6 points out, because the trial order complied with the statutory text of 51.014D, it was a proper use of interlocutory appeal. And that brings me to my—
Counsel, can you maybe explain the reasoning of the court why it reversed its position?
Yes, Your Honor. In Kenyon versus Elephant International Insurance, the Fourth Court looked to the Sabra International Court, to this court's decision in Sabra International, and determined that because the Supreme Court, because this court had looked to the briefs, had expanded the review beyond the issues presented to the court, that the court had, and because the court had stated that the jurisdictional prerequisites belong to the trial court's satisfaction of the statutory text, not to the appellate court's satisfaction of the text, that the jurisdictional prerequisites were met. And this brings me to my second point, that petitioner's imposition of a substantive ruling requirement is an unnecessary procedural hurdle to the fair resolution of the issues here. In Sabra International Travel, this court stated that the purposes of interlocutory appeal are efficiency, accessibility to the courts, and saving the taxpayers money by preventing extrajudicial proceedings. And none of those goals were furthered here by imposing a substantive ruling requirement on interlocutory permissive appeal. Instead, to the accessibility issue here, once again, this is the fifth time that a court will consider the final two issues before it. If this court does indeed remand this case back to the trial court, that will be a sixth judicial proceeding just to gain a rationale by the trial court that will then subsequently be appealed to a seventh proceeding where the appellate court will pay no attention to the trial court's rationale because it is reviewed de novo. Each and every one of these judicial proceedings costs money and effectively separates who can afford appeal and who cannot. It will reserve appeal for parties who have more funds to afford it and will act as a prejudicial barrier line between those parties. And further to the, that also goes to the saving the taxpayer money issue. Here, 7 proceedings to resolve one issue that may even be appealed after the 15th court looks to it is not saving the taxpayer money. The purpose, once again, of interlocutory appeal is to prevent a second trial by the trial court. And that's exactly what will happen here if the case is remanded just to gain the rationale of the trial court. And further, as the record from 5 to 6 points out, the trial court judge in this case dismissed the appeal because it was too hard. We will essentially be remanding a case for a rationale that the judge has admitted is not within his expertise, and then will be appealed and reviewed de novo. So we're remanding for a rationale that doesn't necessarily gain us anything here except extrajudicial proceedings. And finally, this is not an advisory opinion, as the petitioner states, by this court, because the trial court identified the controlling questions of law, which are the 2 questions before the trial, or excuse me, before this court today, the final 2 questions, and it made a decision on those questions. And that was the issue that was appealed. There was not an advisory opinion here. The trial court did its job. It determined the issues of law. It was satisfied that the jurisdictional prerequisites were met, and it granted permission to appeal. That is the exact function of how interlocutory permissive appeal is supposed to function. And it's for these reasons that we ask this court to overturn the 15th en banc court and find that a substantive ruling by the trial court is not a jurisdictional prerequisite to interlocutory permissive appeal. Thank you.
May it please the court. My name is Cody Miller, and I also represent the city of Balboa Bay, the petitioner in this case. Like the jurisdictional issues presented by my co-counsel, the merits issues of this case also involve respondent unreasonably picking and choosing how and when the law applies to them. In my time before the court, I will address issues 3 and 4, which are respectively issue 3, why the Balboa Bay Ordinance banning plastic bags is not preempted by the Texas Solid Waste Disposal Act, and issue number 4, why Officer John Taylor did not owe Lucille Bluth a duty of care to prevent her from slipping on a plastic bag. Turning to the first issue of statutory preemption, petitioner asks this court to find that the Solid Waste Disposal Act, or SWDA, does not preempt the Balboa Bay Ordinance for 2 reasons. First, because the ordinance was not adopted for solid waste management purposes. And second, in the alternative, even if this court finds that it was adopted for solid waste management purposes, it is still authorized under the Home Rule municipality power granted to the city of Balboa Bay. Before beginning petitioner's argument, some key facts should be noted by the court. The record at 3 indicates that Lindsay Bluth, the respondent bringing the action seeking preemption, wanted a ban on plastic bags. The record at 5 then shows that Lindsay got the ban that she wanted, but not for the reasons she wanted it. She wanted a ban for environmental concerns and dealing with floatable trash, not for aesthetic purposes and user safety. However, Your Honors, Section 361.0961 of the Texas Health and Safety Code, which is the preemption clause of the Texas SWDA, expressly prohibits municipalities from adopting regulations on solid waste for solid waste management purposes. This means that if Lindsay had received the ban she wanted for the reason she wanted it, it certainly would have been preempted, unlike the ordinance before the court today. Turning to the first issue.
Well, wait a second.
First point,
say that
the
counsel. I'm curious as to how this could not be for solid waste management purposes, even if the stated reason is not solid waste management. I mean, all plastic bags, they're solid waste. So isn't it intrinsically a solid waste purpose by the very nature of what a plastic bag is?
No, Your Honor, and this brings me to my first reason why this court should not find the SWD preempts. Petitioner does not dispute that single-use plastic bags are containers for the purposes of the SWDA. And therefore, as Justice Malik's dissent in the record at page 10 argues, this court should adopt the same reasoning it applied in the case of City of Laredo versus Laredo Merchants Association. The only question this court must determine is that solid waste management question. In the Laredo Merchants case, this court considered a distinct ordinance from the one before it today. The Laredo ordinance had 3 explicit stated objectives. First, that it was for the prevention of litter. Second, to reduce costs associated with floatable trash. And third, to protect property and life from flooding caused by said floatable trash. Your Honors, the statute, the SWDA, does not define solid waste management purposes, but rather it defines only its component parts. This court in the Laredo Merchants case adopted a plain meaning analysis and found that because the Laredo ordinance had these clear stated objectives regarding reduction of litter, that it was for a solid waste management purpose. This is distinct from the ordinance before the court today because such language is not present in the Balboa Bay ordinance. The record at 4 through 5 shows not only that is that language absent, the ordinance was only adopted for aesthetic values and user safety, but the City Council of Balboa Bay rejected solid waste concerns not just once, but 3 times. First, when Councilwoman Sitwell presented her original proposal for an ordinance based in environmental concerns and solid waste concerns, the rest of the City Council rejected her proposal. Second, when Councilwoman commissioned an independent but inconclusive study regarding the waste issues, 3 out of the 5 council members rejected her study, And finally, even Councilwoman Sitwell joined the City Council in a unanimous decision to pass the ordinance with only statutory findings of user safety and aesthetic value, and making sure that the bags are not used because they contravene the aesthetic values of the city of Balboa Bay.
But council, couldn't this create a problem where cities could get around preemption just by stating different reasons that have nothing to do with solid waste, even if in their mind they're thinking, okay, this is solid waste, but let's get around the preemption issue by stating these reasons that have nothing to do with solid waste? Why is that not a problem?
Your Honor, it could be that some municipalities seek to circumvent state law by passing an ordinance for solid waste management purposes, but then only in the published findings stating some other reasoning. However, that evidence is not before the court today. Again, the record at 4 and 5 shows that the City Council of Balboa Bay specifically considered the solid waste management issues and rejected them. And this brings me to my second point, that
but
even if
council, I'm sorry, not to interrupt your points. Technically we were dealing with solid waste issues in this case, weren't we? I mean, we had sewer blockages. The other client, your other point, going to point 4, she tripped over a plastic bag that was not in use, that was pretty much litter at that point. So how, it still seems like this is a solid waste issue.
Your Honor, if I may address your 2 points respectively in 2 parts. First, the floatable trash and sewage blockage issues were unanimously denied by the City Council when they passed the ordinance. And even during the legislative findings process, 3 out of 5 of the council members rejected the findings of Councilwoman Sitwell's study on floatable trash. And to your second point regarding respondent Lucille Bluth, she wanted an ordinance based on aesthetic values and user safety, the exact ordinance which was passed by the City Council. Lucille Bluth never argued that the plastic bags were a hazardous waste in the terms of a solid waste management issue or that they were litter. She simply wanted a ban because she thought, as the City Council thought, that they were ugly and dangerous to the residents. And this brings me to my second point on the first issue, that even if this court finds the ordinance was adopted for solid waste management purposes, the ordinance can still survive preemption because it is authorized by state law. Again, Your Honors, the text of the ordinance the text of the Solid Waste Disposal Act's preemption clause reads that municipalities are prohibited from regulating solid waste for the purposes of solid waste management unless it is authorized by state law. Here, the authorization comes from a general grant of authority we give to home rule municipalities. Even before the Laredo Merchants case, then Attorney General Greg Abbott in 2014 wrote that there are other ways and other reasons a municipality might regulate plastic bags, which speaks to your question, Chief Judge Hall, about whether all plastic bags are considered. The Attorney General said, no, it is not all plastic bag regulation. And additionally, on questions of statutory preemption, Your Honors, this court and other Texas courts have long-standing, consistently held that if there is any reasonable construction under which both local law and state law can coexist in harmony, then they will be done. And for these reasons, petitioner asks this court to find that the Balboa Bay Ordinance is not preempted by the SWJ, and in the alternative, if it is for solid waste management purposes, that it is still authorized under state law and home rule municipality authority. Turning now to issue number 4 regarding Officer Taylor's duty of care. Petitioner asks this court to find that Officer Taylor did not owe Lucille Bluth a duty of care for 2 reasons. First, there is no statutory legal duty which regulates the discretionary use of emergency signals by first responders. And second, Lucille's injury was not foreseeable and therefore cannot impose a new common law duty upon Officer Taylor. The record at 2 shows that Lucille alleges her injury was caused because she was distracted by the lights and sirens. However, by her own admission, She blames the plastic bag more than she blames Officer Taylor. Yet she is not bringing suit against, there's nothing in the record to show she's bringing suit against Buc-ee's for premises liability and failure to remove tripping hazards, nor is she bringing any sort of suit against the manufacturer of the plastic bag for creating, I don't know, a especially slippery plastic bag.
And
Mr.
counsel,
Miller,
I'm
isn't
sorry.
that her litigation choice to decide who she sues as long as she has the facts on her side as to the negligence of the officer? I mean, is he treated differently for that?
Your Honor, Lucille absolutely has a right to determine how and when to choose, but it is just further evidence of petitioner's point that she is picking and choosing who to sue and not suing all parties responsible, even the one that she views as the most responsible.
Mr. Miller, don't litigants do that every day? They pick and choose the deep pockets. They pick and choose the corporations. They pick and choose the city. What's
Yes,
wrong
Your
with
Honor.
that?
Yes, Your Honor, and that speaks to the why this court should not overbroaden the duty of police officers regarding their emergency vehicles. The only statutory duty governing Officer Taylor's use of his vehicle is found in Texas Transportation Code, section 546.005, which states that operators of emergency vehicles are under a duty to operate their vehicles with appropriate regard for the safety of all persons.
I'm sorry,
That is,
counsel,
for
wait.
this duty to apply.
Counsel, going back to what Judge Skinner just said, are you asking us to hold it against the liability in this case that they've chosen not to sue other parties that could also be liable? Are you asking us to consider facts outside of the evidence in this case,
No, Your Honor. Petitioner is simply asking the court to note that Lucille, in her own affidavit, stated that she blames the plastic bag and its presence more than Officer Taylor. And given that this court has...
Wouldn't that be a fact issue?
Yes, Your Honor, but as my co-counsel has presented, the panel considered de novo and still ruled in favor of petitioner, with considering all of the trial court facts.
But you also talk about how she blames the plastic bag, but the point of the lights and sirens on a police car are to attract attention. So wouldn't that inherently make the risk foreseeable?
No, Your Honor, and if I'll jump to the second point I was going to make regarding the foreseeability of the injury. Lucille's injury was not foreseeable, and therefore there is no common law duty. Outside of statutory duties, this court has repeatedly held that, quote, foreseeability is a prerequisite of imposing a duty, and that was in the decision of UDR Texas Properties LP versus Petrie. And the court has further, again, repeatedly held that risk, foreseeability, and likelihood of injury must be balanced against the social utility of the actor's conduct, the magnitude of the burden on the actor to guard against the injury, and the consequences of placing the burden on the defendant. Your Honors, taking respondent's argument to its logical end, anyone in any circumstance that was startled by lights and sirens could potentially argue that there was a duty owed to them by the police officer. This means if you're driving on the highway and a police officer turns on his lights to respond to an emergency, and that startles you and causes a crash, that you would then argue that you have a duty that had been violated by the officer. However,
well, isn't that distinguishable, because that officer was on duty and would be within the scope of their employment, whereas this officer was on break?
No, Your Honor, Officer Taylor was on duty. His stop at the Buc-ee's was a detour to get some food, but it was not a frolic. He was not off duty and not acting in his duties as a police officer. The record at 5 shows in his affidavit he was on the clock and that he was using his police lights and sirens only to be able to get back to his patrol duties. Returning to
so wouldn't the likelihood of harm be particularly high in this particular set of facts because of the fact that he's in a parking lot full of other cars? There's not one other car, 2 other cars in the parking lot. So that makes it a higher likelihood in your analysis.
Your Honor, respectfully, no. The presence of being in a parking lot does not suspend Lucille's own duty to watch where she is walking. And additionally, no court has held that emergency signal equipment is part of the operating or using of a vehicle. This brings me back to the first point, that there is no statutory duty under which Officer Taylor is bound. The Transportation Code again, requires that to be liable, they must be operating their vehicle. However, this court and other courts have been reticent to expand the definition of operate beyond its ordinary meaning. The mere proximity or setting of a government vehicle is not enough to establish liability, as this court held in Lillo versus Hampshire Finette Independent School District in 1992. Additionally, the alleged tortious act, the negligence which Lucille must be arguing,
Sorry,
must
counsel, that case you just cited, did that also involve a police vehicle, or was it just an ordinary vehicle?
Your Honor, it was a school bus. In the Lillo case, a student injured herself while entering a bus, and the plaintiff in that case alleged that the injury was due to failure of the bus driver, a state employee, to supervise the children adequately. And this court argued and held in its decision that while the bus driver's actions may have been negligent, that because it was not part of the operate or use provision of the Texas Tort Claims Act, which uses similar language to the Texas Transportation Code regarding the operating a vehicle requirement, that liability was not waived. And so simply because the injury happened around a government vehicle, that there was not liability on the part of the state.
But would you agree that operating a police vehicle is more expansive than operating an ordinary vehicle? There's more to it.
No, Your Honor. Petitioner's position is that the ordinary meaning of the word operate is limited to the, as Justice Stiles points out in his dissent, to the ordinary situations that a motorist would expect. Your Honors, simply using the lights and sirens of a vehicle, again, has never been held to establish—
Time, counsel.
Thank you. And may I briefly conclude, Your Honors?
You may.
And for these reasons, we ask the 15th Court of Appeals en banc decision be reversed and the original panel decision be affirmed. Thank you.
Chief Justice Hall, Your Honors, Justice Skinner, Linehan, and Armijo, and may it please the court. My name is Jacob Matthew, and along with my co-counsel, Christina Ta, I represent the respondents, Lindsay and Lucille Bluth. Before I get into my argument, just 2 points. First, opposing counsel's reliance on the comments in the Rules of Appellate Procedure makes too much of too little. The comments specify that motions for en banc reconsideration and panel rehearing are only treated the same insofar as a decision on either motion extends the plenary power of the courts of appeals. And the 2008 amendments did nothing to limit the sua sponte power of courts of appeals to review an appeal en banc. And this is evident because the segment of Rule 49.7 allowing the courts of appeals to do just that was left intact after the amendments. And second, despite opposing counsel's contentions, the Fourth Court of Appeals did not find the substantive ruling requirement overruled by Saber. In fact, its holding had nothing to do with the substantive ruling requirement. That term merely appears 4 times in the opinion. Elephant Insurance merely notes this court has concurrent jurisdiction over permissive appeals and can review them even if a court of appeals declines to accept a permissive appeal, and that where there is a substantive ruling, courts can review closely related ancillary issues. Returning to my argument, the posture of this case perfectly illustrates the importance of adhering to the rules of procedure. Before this court can even reach the 2 underlying substantive tort and preemption issues, which have deep personal implications for the parties involved, this court must first answer 3 threshold questions, each of which could independently warrant dismissal for want of jurisdiction, and each of which could have been easily avoided if this litigation had been procedurally sound. Ultimately, with regard to the en banc court's holding that the trial court abused the procedural mechanism of permissive appeal, we ask this court to affirm. There are three issues before this court. First, that the Court of Appeals lacked jurisdiction because of the absence of a substantive ruling. Second, that the motion for en banc reconsideration that led to dismissal in favor of our clients was timely. And third, that setting aside the jurisdictional questions involved, this court lacks jurisdiction over the remainder of this case. Turning to that first issue, the permissive appeal statute codified as 51.014D allows a trial court to permit an appeal on an order that is not otherwise appealable, but subject to critical limitations. We contend, and the Texas Courts of Appeals agree, that in addition to the existing statutory limitations, a substantive ruling requirement is also necessary in order to ensure the legislature's intent is effected. We agree that this court's holding in Saber articulated a broad presumption in favor of preserving appeal, which is also in accord with this court's longstanding rule in Verburgt. But, Your Honors, the procedural history of this case in the trial court must fall beyond the scope of Saber and Verburgt. Specifically, as seen in the record on pages 5 and 6, Judge Ping's own reasoning for allowing the permissive appeal, in his own words, was, "This case is too tough. I'm new to the bench anyway. Let's just let the Court of Appeals decide this. I'll deny the motion, but grant permission to appeal so I don't have to actually decide this mess." For the record, let's just say summary judgment is denied because of a fact issue. Yes, the facts are in dispute. Let's go with that. So ordered. If this court's holding in Saber is followed to the letter, as opposing counsel suggests, then the fact that Judge Ping's unperfected, punted decision was merely accepted by the appellate court would be sufficient to perfect it. But this court must reject such reasoning wholesale. The law is not so rigid and unbending that it cannot resolve clear violations of the rules and abuses of procedural mechanisms, as occurred here. If such manifest blatant procedural abuse is not sufficient to countenance affirming the en banc court, we contend that 51.014D's language inherently contains a substantive ruling requirement for three reasons. First, to accord with the overwhelming weight of authority in Texas. Second, because a fact issue cannot be the basis of an interlocutory appeal. And third, for reasons of public policy. Turning to that first point, the Texas Courts of Appeals have resoundingly held that a substantive ruling requirement exists, and we ask this court to do the same. Anything less, as the San Antonio Court of Appeals held, would relieve the trial court of its role in deciding substantive issues of law properly presented to it. It is also wholly inappropriate for a question of fact to be the basis of an interlocutory appeal. Such appeals must involve questions of law, and interlocutory orders, as the Waco Court of Appeals held in Borowski versus Ayers, cannot involve a controlling question of law until the trial court has made a substantive.
In some cases, don't we have interlocutory appeals of mixed questions of law and fact? It's ultimately a question of law, but you have to resolve underlying fact issues to get to that legal ruling, like a plea to the jurisdiction, for example.
Yes, Your Honor, that's certainly the case, but we contend that at the very minimum, a substantive ruling requirement is required in order to achieve the effect that the legislature intended to achieve with the permissive appeal statute. And that
where did this substantive ruling requirement come from? Because as the petitioner stated, it's not in the statutory text. So where did we get this idea of substantive ruling from, and why should this court then apply this substantive ruling requirement if it's not specifically written in the statute?
Your Honor, the first court to find such a substantive ruling requirement was the San Antonio Court of Appeals in Gully versus State Farm. And subsequently, the first district in Houston, Fort Worth, Austin, San Antonio, Dallas, Texarkana, Amarillo, Waco, Eastland, Corpus Christi, and the 14th District of Houston all found the same way, and primarily for two reasons. First, in order to achieve the intent of the legislature, and second, in order to ensure that the prohibition against issuing advisory opinions is held to. And the critical legislative history that applies here shows that the law was intended to provide for the efficient resolution of certain civil matters and to make the civil justice system more accessible and less costly. And in fact, in Saber, this court acknowledged that permissive appeals can only be beneficial when they allow the parties to be spared the inevitable inefficiencies of the final judgment rule in favor of the early efficient resolution of controlling uncertain laws. Opposing counsel is wrong that the prohibition against issuing advisory opinions has no applicability here. This particular misuse of the permissive appeal statute overlaps significantly with the policy against issuing advisory opinions. That prohibition exists to promote the separation of powers. Not only does the lack of a substantive ruling open the floodgates to costly, protracted, and inefficient litigation and appeals, without a substantive ruling, the courts of appeals are forced to sift through the record and are only capable of guessing at the controlling legal issues. In effect, they are forced to take on the duties of trial courts, undermining the hierarchical organization of the Texas judiciary. In this case, this very case showcases the confusion that arises when trial courts are derelict in their duty. It involves 3 threshold questions, each of which could independently warrant dismissal, and that must be answered before this court can even get to the underlying substantive issues. Your Honors, affirming the en banc court will promote a clearer and more rigorous process for permissive appeals, advancing the rule of law and favored policies of this state. Turning to the second issue. Justice Armijo, as you noted, the issue of timeliness essentially requires this court to assess the Dallas Court of Appeals opinion in Cruz versus Ghani. But contrary to petitioner's claims, the Ghani majority got it right, and we urge this court to adopt its sound reasoning. This is because when a rule of procedure is clear and unambiguous, courts must construe the rule's language according to its plain or literal meaning. Here, the plain text of Rule 49.7 contemplates 2 bases for filing a motion for en banc reconsideration, either within 15 days after the court's order, or second, within 15 days after the court's denial of the party's last timely filed motion for rehearing. Here, it is undisputed that the motion for panel rehearing was timely filed, as seen in the record on pages 6 and 8. And so filing the motion for en banc reconsideration within 15 days of the denial of the motion for rehearing rendered it timely. And despite Chief Justice Stiles' dissenting argument to the contrary, seen in the record on pages 13 and 14, the plain text of Rule 49.5 only applies to further motions for rehearing. None of its requirements apply to motions for en banc reconsideration. And we know this.
So what's the line? At what point would a motion for en banc reconsideration be untimely?
Well, the rules are pretty clear, Your Honor. Despite opposing counsel's contentions that the motion for en banc reconsideration is untimely here, there's no dispute that the motion was filed within 15 days, as the rules specify. A motion filed within 16 days would not be timely. That's relatively clear. And we know that Rule 49.5 does not apply because the title of Rule 49.5 is further motions for rehearing. And so other than the rule that a motion for en banc reconsideration be filed within 15 days after a timely denial, there are no other requirements for a motion for en banc reconsideration. And so the term "when permitted" refers only to the discretion vested in the courts of appeals to accept or reject conditional motions for en banc reconsideration. Here, the court granted the conditional motion, and so all the requirements of 49.7 were met. Turning to the third issue.
What about the modification requirement, that the requirement that the opinion be modified in some way?
Your Honor, as this court held in Hartman, the courts of appeals always retain the power sua sponte to hear an appeal en banc. That power has remained intact. And so the term "when permitted" refers to the discretionary power vested in the courts of appeals to accept or deny a motion for en banc reconsideration as long as it meets that initial threshold of being filed within 15 days. Here, the Court of Appeals decided to accept it. And so if we look at the sua sponte power, it would have been permitted under that basis. But returning to the third issue, as this court held in Saber, where a permissive appeal is granted, it is treated the same as an accelerated appeal, under which this court's jurisdiction is coextensive with the courts of appeals. And so anything which would preclude jurisdiction in the courts of appeals would bar jurisdiction here. Here, as seen in the record on page 7, the trial court failed to adhere to the substantive ruling requirement. And moreover, as we've already argued, allowing the appellate panel's mere acceptance of the unperfected appeal to render it perfected would sign off on gross procedural abuses by the trial court. This is unconstitutional. It violates Article 5, Section 3, which places limits on judicial power. And it is inconsistent with the principle this court articulated in State versus Naylor in 2015, that Texas courts lack the authority to expand the scope of their own jurisdiction. Such patent dereliction of these constitutional limits risks subverting the integrity of the Texas judiciary. And so this court must recognize that its jurisdiction over this case is only limited to the jurisdictional question itself. It must resolve that question in the negative and affirm the en banc court. Your Honors, in conclusion, the Verburgt principle relied on so heavily by opposing counsel is not unlimited. The right of appeal is only preserved where it is not absolutely necessary to deny appeal to preserve the purpose of a rule. Opposing counsel will have us invert the Verburgt principle and preclude jurisdiction to hear an appeal where it is arguable that there's some sort of technical deficiency. Here, the rules of procedure advance the interests in judicial economy, swift resolution of disputes, and the decreasing costs for the parties, but those interests must necessarily be secondary to the ultimate purpose of the rules, which is to preserve the integrity of the judiciary. Allowing appeal to be preserved here, given the manifest abuses by the trial court, would violate the Verburgt principle, and it would send a message to all the courts of appeals and throughout the state of Texas that this court will look the other way when it encounters gross, overt abuses of extraordinary procedural mechanisms. This would subvert the integrity of the judiciary and poison the institution in the eyes of the public. And for these reasons, this court must affirm the en banc Court of Appeals. Thank you.
Your Honors, and may it please the court. My name is Christina Ta, and I also represent the respondents, Mrs. Lindsay and Lucille Bluth. I will be addressing the remaining issues before this court today. First, that the Balboa Bay bag ban manages waste and is therefore preempted by the Solid Waste Disposal Act. And second, that Officer Taylor owed Lucille Bluth a duty of ordinary care when he used his emergency vehicle equipment for personal reasons. The respondent respectfully requests this court to affirm the en banc panel's denial of summary judgment. Turning now to the first issue, the Balboa Bay bag ban cannot be allowed to stand because it directly conflicts with the Solid Waste Disposal Act and is therefore preempted. Texas Constitution, Article 9, Section 5, states that a city's ordinance cannot conflict with state law. Here, per page 5 of the record, the city of Balboa Bay passed a bag ban. This bag ban seeks to prohibit business owners from providing single-use plastic bags at checkouts and points of sales. Such a complete prohibition, however, directly conflicts with the Solid Waste Disposal Act, otherwise known as the SWDA. The SWDA has three relevant parts to it. It provides that a local government may not adopt an ordinance to prohibit or restrict, 1, for solid waste management purposes, 2, the sale or use of a container or package, 3, in a manner not authorized by state law. The only relevant issue in this case is whether the city's ordinance involves a solid waste management purpose. This court should find that the city's ordinance does manage waste for two primary reasons. First, because such a reading aligns with the plain language of the statute, and second, because the effect of the statute manages waste. Before we begin, it's important to note that this court has already, in one instance, found that a bag ban constitutes the management of waste in City of Laredo versus Laredo Merchants Association in 2018, in a unanimous decision with no dissenting voices. Now, turning to my second point first, the effect of the Balboa Bay bag ban manages waste. The petitioner here has argued—
Well, maybe that's the effect of the ban, but if the city council didn't expressly say this is the purpose of the ban, then it's not for solid waste management purposes, right?
No, Your Honor. Despite petitioner's contention that the city's asserted purpose of beautification and user safety is controlling in determining the question of preemption, we do not actually determine purpose of a statute based on a city's assertion, but instead we determine the purpose based on an objective analysis of the effects of the statute, as urged by this court in Southern Crushed Concrete versus City of Houston in 2013. As an example, in that case, the city argued that its ordinance was not preempted by the Texas Clean Air Act, but because its purpose was to regulate land use, not air quality. Nevertheless, this court held that the ordinance was preempted, reasoning, as your Chief Justice reasoned earlier with the petitioner, that a subjective reading of purposes would, in effect, allow cities to circumvent preemption laws simply by manipulating the ordinance's stated purpose or by using magic words. Therefore, even though the petitioner here insists that the ordinance was passed for aesthetic values and user safety, such insistence should not be dispositive. Instead, we must examine the history and the effect of the ordinance. This court should not ignore the foundation upon which the ordinance was based. Per page 4 of the record, the original bill was introduced by Councilwoman Sitwell, and she did so based upon a finding that plastic bags presented an environment and solid waste concern. On that same page, she even commissioned an independent environmental study to examine the impact of discarded bags. This court should not ignore that history. Moreover, and more importantly, if this court allows the bag ban to stand, even though its primary effect is the management of waste, this court, in effect, would be stripping the SWDA of all of its preemptive power, because any municipality could then manage waste in violation of the statute simply by manipulating its stated purpose. Now, returning to my first point, this court should also find that the bag ban manages waste because of the plain language of the statute.
Well, counsel, at the point where you're getting abuse and that multiple people or multiple city councils, are passing bag bans for aesthetic purposes when they're clearly not, then at that point, wouldn't the legislature again have a duty to revise their language? Why is that our job as the court when the legislature has the opportunity to amend that language at a later date if they find abuse?
Your Honor, I'm sorry, can you repeat the question one more time? I'm not sure I understood it.
Well, I'm asking if, if we're worried about people abusing the statute and changing up the language to say that it's for aesthetic purposes rather than for waste management to avoid preemption, then at that point, couldn't the legislature, in their duties as being the legislature, rewrite the statute to protect against those abuses? Why is that the court's job and not the legislature's job?
Well, Your Honor, the statute is actually already explicitly clear because it states in the statutory language itself that a local government may not adopt an ordinance to prohibit or restrict unless authorized by state law issues dealing with solid waste management. And given that this court had already, prior to the adoption of the SWDA, adopted this the theory under Southern Crushed Concrete that we should observe an objective analysis in determining preemption statutes, it's clear enough given the language of the statute coupled with the way this court already analyzes preemption issues to address concerns where municipalities try to abuse the preemption laws by using different stated purposes. And furthermore, this court's duty, as Your Honor pointed out, is to define the language of the statute. And using the plain language analysis of the term management as provided by the Texas legislature, the bag ban does constitute a solid waste management purpose. Under Texas Health and Safety Code, section 361.008, subsection 18, the Texas legislature has defined management for us. There, the Texas legislature defined management as, and here I'm only going to read the relevant parts of the statute. Management is defined as the systematic control of the activities of generation, processing, treatment, handling of waste after it is created, or disposal of solid waste. In City of Laredo, this court found that restricting the creation of waste by instituting a plastic bag ban, in effect, restricts the generation of waste, such that it falls into the definition of management. If this court were to define generation any other way, it would render generation meaningless. So this court needs to find that bag bans do restrict the creation of waste, such that it falls under the definition of management. This court should hold that City of Laredo defined generation correctly, giving the word its ordinary meaning of to cause to be or to bring into existence, such that it encompassed bag bans. And as Chief Justice Heck pointed out in his opinion in Laredo, It's not this court's job to judge whether a city should be able to regulate a particular issue, but the state legislature's job. This court's primary duty is to enforce the language of the statute, which is exactly what it did in Laredo when it stayed faithful to the language of the SWDA and found that bag bans manage waste. Accordingly, this court should follow the spirit of the law and reaffirm the holding in Laredo and find that today the Balboa Bay bag ban is preempted by the SWDA.
I just want to make sure I'm clear on your position. Your position is that all plastic bag bans, regardless of the reason they're passed, they are preempted by the statute. Every single plastic bag ban out there.
If there is a commercial sale or use associated with it, then yes, Your Honor, it would be preempted per the language of the statute in the SWDA, and which is exactly what this court already found in City of Laredo. Turning now to my second point, or to the second issue, Officer Taylor owed Lucille Bluth a duty of ordinary care because he abused the privileges of his office by using his emergency vehicle equipment for personal reasons. The duty of ordinary care is a duty to act as a reasonably prudent person would under the same or similar circumstances. To determine whether a duty exists, this court engages in a two-part inquiry. First, foreseeability of harm, and second, the unreasonableness of the harm, as provided by this court in UDR Texas Properties versus Petrie in 2017.
Counsel, if I may interrupt, how would it be foreseeable that by turning on his lights and sirens, a pedestrian in the parking lot behind him falls down?
Well, Your Honor, generally loud noises are startling, and then people thus startled can injure themselves. Courts generally accept this simple fact and presume foreseeability in cases involving sudden bursts of loud noises that cause fright or distraction to people. For example, in Hughes versus Metro Government of Nashville and Davidson City, the Tennessee Supreme Court in 2011 held a defendant liable for tortious injury against the plaintiff because the defendant, while driving heavy machinery, dropped the bucket of his front end loader onto the pavement and created a loud scraping noise. This sudden noise startled the plaintiff, a pedestrian who was walking on the side of the road, and as a result, he jumped, tripped, and injured himself. In that case, the court did not linger on a foreseeability analysis. Instead, it concluded it should have been foreseeable to the defendant that by causing the sudden loud noise, that nearby persons could be startled, frightened, shocked, trip, and be hurt. That analogy extends to the current circumstances because officers should know that the use of emergency signals have the potential to scare surrounding bystanders and make them unsure.
How would the officer be expected to do his job if every time he turns on his lights and sirens, he has to take a duty of care to every single person around him that he can't pursue the bad guy because someone might trip on a plastic bag?
No, Your Honor, the duty of care would only arise if the officer is using his lights and sirens inappropriately for personal reasons and not responding to an emergency.
Counsel, is there some sort of case that supports that argument that you're making?
That a duty of care should be afforded when officers are using their lights and sirens for personal reasons, Your Honor?
Right, the personal reasons thing.
Yes, Your Honor. So this actually takes me to the second prong of the inquiry, which is the unreasonableness of harm. To determine whether or not we should impose a duty upon a defendant, courts engage in a risk utility analysis. Therefore, an officer owes a duty to others when the risk he imposes on them outweighs the social utility of his actions. Now, while I don't have a case on hand to tell you whether or not this court has addressed that issue, there are statutory reasons for why this court should impose a duty. This court should find that an officer owes a duty of care when he uses his emergency vehicle equipment for personal reasons. First, because states already place limitations on officers' use of emergency equipment for non-emergency purposes.
Counsel, what about the petitioner's argument that he was using it for his employment purposes because he needed to get out of that parking lot and get to work?
Your Honor, the respondent would argue that even if that was the case, he was not responding to an emergency. And as such, the use of lights and sirens was unwarranted. And here, Texas law has already placed limitations on officers' use of equipment when not used for emergency purposes. And second, because under a risk utility analysis, there is no social utility when an officer uses his equipment for personal reasons. For example, some states find that when an emergency vehicle driver violates traffic regulations for non-emergency purposes and thereby causes injury to another party, there's a presumption of negligence, which can be seen in Potosi versus New York City, which was heard by the New York Appellate Division in 1976. Other states find that even if an officer is responding to a call, unless it is an emergency, police officers are not allowed to activate their vehicles' red lights or sirens and must obey all traffic laws, as seen in Herberts versus Coburn by the Arizona Appellate Court in 1977.
Is there a similar rule here in Texas?
Absolutely, Your Honor. Texas does not allow drivers of emergency vehicles to violate traffic laws unless they are responding to emergency calls or conducting police escorts, as can be seen in Texas Transportation Code, Section 546.002B. Given that Texas law does not permit the frivolous use of emergency equipment.
So is it your contention that the officer in this case was breaking the law by activating his emergency lights?
Your Honor, he was certainly violating Texas Transportation Code, Section 546.002B, when he was not operating his lights or sirens in an authorized manner. And it's important to note, as Justice Skinner has already, that Officer Taylor, per page 3 of the record, was not responding to a job-related call. Sure, he was trying to get out of the parking lot to get back to work, but he didn't believe that there was an ongoing emergency and was not actually actively performing any duties when he turned on his lights and sirens. He explicitly states that he turned on his equipment because he was frustrated that he would have to wait his turn in line to get out of the crowded parking lot. The respondent asked this court today to hold that officers owe the public a duty of ordinary care when they use their emergency equipment for non-emergency purposes.
I just want to make sure I'm clear on your position again. If the officer in this case had been responding to a crime, a call that came in, he would be allowed to use his emergency lights. So we're just looking at the reason why he was using them. That's all we're looking at.
Your Honor, I see I'm about to run out of time. Can I answer your question and then quickly conclude?
You may.
Absolutely, Your Honor. That is the line that the respondent is asking this court to draw today, that there is a difference between when an officer uses his emergency equipment for emergency versus non-emergency purposes. Because under these circumstances where Officer Taylor was using his equipment for non-emergency purposes, the risk utility analysis weighs in favor of finding a duty because there is no social utility unless an officer is appropriately using his equipment. And therefore, Your Honors, as a matter of public policy, this court should affirm the en banc panel's denial of summary judgment. Thank you.
May it please the court, just 2 quick points on rebuttal. First, to the en banc reconsideration issue, counsel's characterization of the 2008 comments are misleading. The comment reads in its entirety that Rule 49 is revised to treat a motion for en banc reconsideration as a motion for rehearing and to include procedures for the governing the filing of motions for en banc reconsideration. Once again, the comment does not distinguish between sua sponte motions raised or motions filed by the parties. Contrary to petitioner's contention, there is simply no authority in the text to draw a red line through Rule 49.5 simply because it doesn't support petitioner's position here. And to the second point, respondent misquotes Texas Transportation Code. The state code does not forbid officers from using their lights. It merely requires them to use them if they are going to break a traffic law. The record at 5 shows that Officer Taylor was on duty and trying to get back to patrolling Balboa Bay to keep the streets safe. He was not using his lights for personal reasons. And for these reasons, we ask this court to reverse the 15th en banc court. Thank you.
Thank you, counsel. The case is submitted.